देखिए, sections 396 and 397 operate in two different spheres. Section 396 is a section which permits amalgamation of two companies by the central government if it believes that such amalgamation is essential in public interest. Now, section 396 is part of a group of sections, sections 391 to 396, which provide for amalgamation. Under 391 to 395, the provisions relate to what might be termed voluntary amalgamations, amalgamations between two companies which seek to amalgamate and have to thereafter progress through a procedure which is laid down under those sections by necessary sanctions from the general body of shareholders, from creditors, and then finally consent of the court. 396, however, provides that notwithstanding anything provided in 394 and 395 of the Companies Act, the central government may, if it feels essential in public interest, pass an order directing an amalgamation. In my view, section 396 is to be read along with the other provisions of that chapter relating to amalgamations, and in my view, it is not as if the element of consent can be entirely dispensed with. This is because the element of consent comes in 391 of the Companies Act. Section 396 talks of notwithstanding anything in 394 and 395 only. So the element of consent of the companies which are proposed to be amalgamated is an essential ingredient in my view. This is further fortified by the fact that when the government laid down certain guidelines for the applicability of section 396 in 2011, those guidelines expressly provided for consent of 100% of the shareholders and for 90% of the creditors to be obtained before a sanction under 396 could be given or an order could be passed under section 396 by the government for amalgamation of such companies.